Hello, and welcome to Ipsy Dixit, a podcast on legal scholarship. I'm Lou Nguyen, a student at Oberlin College and co-founder of the Oberlin Policy Research Institute, an undergraduate public policy organization at Oberlin College. My guest today is Joshua Fershee, professor of law at West Virginia University College of Law and head of the Economic and Community Development Group in the West Virginia University Center for Innovation in Gas Research and Utilization. Today, we will discuss his article, The End of Responsible Growth and Governance, the Risk Posed by Social Enterprise Enabling Statutes, and the Demise of Directive Primacy in Transactions, the Tennessee Journal of Business Law. Welcome, Professor Fershee.
Thanks for having me.
So to get us started off, can you tell us a little bit about this paper and how you got into writing about it?
Sure. This is a paper that I'm part of the Business Law Professor's blog, and I write there regularly. And this paper really grew out of some of my writing there, of looking at how different groups interested in corporate social responsibility and businesses taking responsibility for social challenges and giving back to the community. And in looking at that, I've been seeing a variety of changes, both in terms of how courts are reviewing the roles and responsibilities of those in charge of companies, and in our expectations of what companies will do. As an added overlay, we've had some recent developments of a few different kinds of ways to challenge or check businesses and their social responsibility efforts. Some private certifications like B Corp, which is a kind of a good housekeeping seal of approval kind of process that has is just an outside overview or review of what a company does. And then you have the state laws that actually govern what entities do. And in recent years, we've had a few different kinds of entities being created called benefit corporations, for example, that have a specific public benefit option in their formation, which makes them different from the traditional corporation. And looking at how that was developing, I started considering what the impacts are of these well-intentioned statutes and goals of folks, and decided to look and see, do we really think that these well-meaning efforts are going to lead to the intended outcome, and that is more socially responsible businesses? And my first take is no, they're not.
So in this paper, the title basically says that there's two risks. First of all, social enterprise enabling statutes, and then the demise of directive primacy. Would you like to go into both of those things and why the growth and waning of those things would be a difficult problem in the business law community?
Sure. So the first issue is when you create a new entity type, and in this context, talking about the state level benefit corporation, in addition to the traditional corporation, it means that you have, it runs the risk of implying that if you want to serve the public benefit, you must be a benefit corporation. That is, it means that if you're a traditional corporation, in fact, you cannot work for the public benefit, and that your efforts to work for the public benefit might somehow be beyond the scope of your charge. And I think that's problematic. Historically, we have allowed businesses to make decisions about whether they want to give philanthropically, whether they want to pay their employees more, if they want to keep a business operating in, say, Pennsylvania, as opposed to moving it overseas. We've allowed companies to make those decisions. And there's at least an implication when you have this new entity form to say, well, if you want to take into account the public benefit, you really should be that kind of entity, right? Your traditional entity can't do that. It's only profit-driven and solely profit-driven for the shareholders. I think that's a flawed way and not inconsistent with how businesses have been traditionally run, or at least allowed to run. But the creation of these statutes, I think, creates an implication that, no, if you're a traditional corporation, you have one goal, and that is profit as a singular motive. And if you want to have take other things into account, you need to be this other kind of entity. And I think that's problematic. The second part of this is the concept of director primacy, which is probably less commonly understood for people, in the sense that as we look at companies, we have to consider who's in charge. And so on the one hand, people often think of, well, shareholders own the company and they are in charge of the company. And there's some truth to that, but historically, shareholders actually have a very limited role in how companies operate. That is, shareholders put up some money. They have they are investors who provide the capital to make the company go. But in exchange for that, they get protection, limited liability protection, which means they don't have any obligation to pay for the debts of the corporation beyond what they've invested, right? Just the shares that they paid for, but they can't lose their house over it, or any of their other income. Is just what they've invested in the company. So when they do that, shareholders have limited rights. They have a right to the residual interest, whatever is left over if the company is liquidated and sold. If the company makes profits and chooses to distribute those profits, the shareholders get their pro rata share of that. And they have some very limited rights to vote, to choose who the board of directors is, and to choose a few other types of things, usually large-scale things, decisions that will end or fundamentally change the entity, so a merger or a sale, that kind of thing. But as to day-to-day operations, shareholders do not have really any power. They are not given the ability to do much with the corporation at all, other than tell the people that they chose to run it, that the board of directors, if I don't like what you do, I will vote you out next time, or remove you from office. But that's all shareholders really get to do. And yet we've had an emerging view that the corporation has to be run for the shareholders the way the shareholders want. And I think that's flawed and inconsistent with what we have traditionally, how we've traditionally viewed corporations. That's where director primacy comes in. Shareholder primacy says the shareholders are the ones who are not only get the fruits of the labor, but they are the ones who are in charge. Director primacy says, no, once the directors are hired, it is their job to run the entity. They make the decisions. They hire the people who are going to run day-to-day operations. They choose who the president and the CEO will be and who shall choose to work with them in other contexts, who their general counsel will be, and who will hire the other employees they need to get the job done. And so the director's role, in my view, is to work toward shareholder wealth maximization, that is to maximize the wealth for shareholders, but the directors make the decision as to what that means. So directors decide, we want to be a long-term company or we want to be a short-term company. That is, we're trying to generate short-term and quick profits, or are we trying to invest for the long term because the real value of this entity is going to be not just 1 year from now and not just 5 years from now, but 10, 20, and 30 years from now. And that the directors make those decisions on behalf of the shareholders with the shareholders' interests in mind, but with regard to what the directors think is best. Directors are in charge. And that's where we've seen some changes, particularly in Delaware, some suggestions by the court that no, shareholder wealth maximization means making decisions that shareholders would want, near term or long term, and it becomes implied that it's more near term. And I think that's the great risk. The best example I can give you is, and I think I use it in the article, I know I did in my blog post, so I'm sure it is there, is when we look at companies like Krispy Kreme and Boston Market, companies that expanded really, really quickly, and there was a Krispy Kreme going in, seemed like every hour, and Boston Market was all over the country, and they expanded really, really fast, trying to generate as much profit as they could, and of course they overplayed their hand, and both of those suffered dramatically, and shareholders lost. On the flip side, we have companies like Craigslist who provide a very community-based focus. They charge for a limited amount of things. Typically, I think it's New York and San Francisco where they charge for ads. Otherwise, Craigslist is free. And yet they were one of the leading companies for internet kind of classified ads. Um, there's little question that Boston Market and Krispy Kreme that you can pursue and try and get as big as you want. And yet there have been significant questions about what Craigslist was doing, for example, is in the best interest of the shareholders.
Sure. The first question I have is related to the growth of these public benefit corporations and the expectation that this might be the correct form if you want to be socially active as a corporation. How did these kinds of statutes under state law develop?
Well, it appears that there was a small group of people who were advocating for the concept, and it, I think really comes out of, and there's some differing views on this, but I think my view is that we started seeing a desire for, there's a movement, a CSR movement, or corporate social responsibility, and a desire for a way for people to signal, companies to signal that they are interested in the public benefit. And so we saw a couple of things happen. The state of North Dakota passed a publicly traded corporations law that provided more protections for shareholders. And that was, again, a small group of people who championed that. They tried to pass it in a couple of states and it failed, and ultimately passed in North Dakota to give shareholders more rights to run the company. It was an optional, type of entity form. To my knowledge, there's still only been one entity that chose to switch to that type of company in North Dakota. And so it was more of a statement that we want companies to be more beneficial. In parallel, we had the private certification that I mentioned earlier, the B Corp certification, which incidentally doesn't matter if you're a corporation. They also certify LLCs and other types of entities. It has to do with how they operate. But there was this kind of private certification of the benefit corporation, and evolving out of that, I think some folks said, well, maybe we should have this be not just a voluntary thing, but we should make it an opportunity under state law. And in fact, currently, B Corp certification is working toward requiring that anybody who's going to have a B Corp certification opt into their state's benefit corporation law or benefit entity law if they have one. And I think it was Etsy was the first who had been one of these B Corps, is dropping out of that in part because of the requirement that they reform as a B Corp, or as a benefit corporation rather, to keep those distinct. So I think the origin really was people trying to send a message that we'd like companies to be more socially responsible. And that led to the passage of these statutes.
So another issue that you brought up is the willingness of state courts, for example, Delaware, to hold in eBay versus Newark that there's this responsibility. To what extent is this, an issue of state and federal law, or is this like an issue of overzealous judges, or how do you see this kind of framing out?
Well, this is almost exclusively a state law issue. And Delaware is unique in that it is, a large portion of the publicly traded companies in our country are Delaware-based corporations, and they've been very much a leader in all things related to business and corporate law. And so this is a Delaware issue, not exclusively, because Delaware has been very influential around the country in corporate law. But it is particularly acute in Delaware law, both because of the number of cases that we see there and because of the way Delaware's law is structured. And so you mentioned correctly the eBay versus Newmark, which is the Craigslist situation. eBay invested in Craigslist, and Craig Newmark, who was the founder, when they allowed eBay to buy in, they got into something of a dispute on a variety of levels, and Craigslist's board took some measures that I agree with the court were fairly aggressive. But Chancellor Chandler, who wrote the opinion in that case, went beyond just saying, I think that you've operated in an incorrect way, and looked at Craigslist and said, Craigslist has as their mission the goal of public benefit. And he said that it was his view that Craigslist was operating incorrectly under Delaware law, because once you choose to be a for-profit entity, you have to give up some version of this personal or private benefit. And so he really looked at saying that the whole purpose of the entity is flawed. And Chancellor Chandler said, the corporate form in which Craigslist operates, however, is not an appropriate vehicle for purely philanthropic ends, at least not where the other shareholders are interested in realizing a return on their investment. So he said, by having, and this I'll quote again here, having chosen a for-profit corporate form, the Craigslist directors are bound by the fiduciary duties and standards that accompany that form. Those standards include acting to promote the value of the corporation for the benefits of its stockholders. Right. So Chancellor Chandler there says, you're using the wrong type of business entity if you're going to run a business like Craigslist. I find two major flaws with that. First, Craigslist has been, and had been, a profitable company for a number of years. Chancellor Chandler seems to think they could have been more profitable. But the fact that they were profitable in and of itself, to me, suggests that is sufficient. Second, Craigslist had said, we believe we're Craigslist and a market leader where we are because of how we operate. And, and that's where I would use the Krispy Kreme and Boston Market examples. By not overly monetizing their process, as some of those other entities did, they were able to hold their market share and stay connected with the people who use the entity. And to get in the way of that, to say, well, that's not the purpose of a business, is flawed. It would be as though you had a local restaurant, for example, that does really, really well. And the shareholders say, you need to franchise, open more of these. And the owner of the restaurant might legitimately say, I don't think I can replicate this and be successful. It's going to dilute the brand. It's going to spread us too thin. And so not only will the new locations not work, but we might put the original one at risk. That's supposed to be the decision of the directors, those in charge of the business. And here we see Chancellor Chandler saying, no, I think some shareholders want to take a different path. And when you keep espousing philanthropic goals, that takes you out of the corporate form. And I think that's flawed.
So in your paper, you bring up the company Ben & Jerry's, which has a focus on these kind of very politically active stances and economic justice. And you say that, the corporations like Ben & Jerry's or Etsy, which are focused on the social good, may be negatively harmed by these business law developments. Would you like to elaborate on that?
Yeah, and so those companies that formed with this kind of economic justice and private benefit or public benefit, I should say, mission of, we bring these companies out to share with each other and to develop a community. What I was just talking about with Chancellor Chandler's view of Craigslist is not limited to Craigslist. Certainly some of the early forms of Ben & Jerry's, early forms of Etsy could have a similar legitimate criticism of saying, well, you are working on this for philanthropic goals. You're using economic justice and community development, not profit seeking. And at least in Delaware, Chancellor Chandler seems to be saying that's not the right purpose of the entity. Add to that concept, right? This here I'm seeing an erosion of director decision making. Now Delaware has a benefit corporation law. And so it really suggests, okay, if you're going to do this public benefit kind of work, you need to choose the benefit corporation model. Well, the challenge with that is, one, we have companies like Ben & Jerry's and Etsy and others who have been, and Craigslist, who have been working in their corporate mission for some time under the traditional model. But second, by switching to a new entity form, and having to at least, runs the risk of scaring off shareholders by forcing these entities to make an overt change in their, or at least imply that they're making an overt change in their business model, when until very recently, nobody had a problem with them running their business, their for-profit business, in that way. In fact, I would argue, and the market seems to show, that at least for those companies, the Ben & Jerry's, the Etsy's, the Tom's Shoes of the world, that their philanthropic goals were an economic competitive advantage. And I think things that drive both social benefit and competitive advantage should be embraced and not hindered in the way that I think this combination is going to do.
So you point to one example, CVS Caremark announcing that they will no longer sell tobacco products, and then hedging with additional statements about economic sufficiency and other things. So do you think that this trend is going to continue with other large corporations like CVS Caremark if this trend continues?
Well, I think it's a risk. So one of the things we saw with CVS Caremark was they made their public health statement, as you correctly noted. They say, we're going to do this because it's the right thing to do. But also, by the way, we're trying to build this healthcare brand. This is a good business decision, and we're going to do this. We will make the money back and more by building our healthcare brand, and therefore it makes sense. All of that is fine. I just think that the second part shouldn't have to be explained at that level, as long as the directors are not operating in any way that they're getting some personal benefit by making this decision. We've seen two other recent criticisms of companies making decisions. So, for example, Nike got a lot of criticism for their ad with Colin Kaepernick recently, and almost immediately there was a drop in their share price, and it had people talking about how they were squandering their shareholders' resources, and that they lost almost $1 billion in market cap in 24 hours by doing this, and that this was just reckless and unexplainable, or a bad decision. First of all, advertising is a decision that directors make. Shareholders don't get to vote on advertising, or you'd never have creative advertising. You can't rule by consensus for those kinds of decisions for large publicly traded companies. But second, 48 hours later, Nike's share price had gone up, and was, in fact, I can't remember exactly the number, but was noticeably and significantly over the number it had been right before the Kaepernick ad. And my argument is, I don't think we should be questioning either one. They shouldn't, you can look at it from a profit perspective, but they shouldn't be limited in being able to do things because it worked or because it didn't. That's the essence of what directors are supposed to decide. If people don't like how the directors are operating, vote them out, but it shouldn't be a breach of fiduciary duty for them to take that kind of risk. The second place that we saw it was Dick's Sporting Goods not long ago, after some of the tragic gun violence, decided that they were going to no longer sell the same number of guns, and they were going to put some restrictions and only sell certain weapons to people who were over 21. And again, they faced similar criticism because the head of Dick's said, this is the right thing to do, and I don't really care what the financial impact is. There's two layers to that statement itself. One, shouldn't businesses be able to say, we have a sense of right and wrong, we're going to operate within that, because it is implied that by doing the right thing, our business will thrive, and if we do the wrong thing, the business will not. But second, we also saw a similar thing there. They had a drop in revenues and an increase in profit because the space that they were giving up, where they took some of the weapons off the floor, was replaced with other higher margin items. So in fact, they reduced revenues but increased profit, which is a thing we often want to do from a business perspective. But again, we've asked the board of directors to run the company. It is their call to do what is right for the company. And sometimes if in their view what's right socially is the same as what's right for the company, that should be their call, and that the recourse should not be going to court saying they did something illegal. Instead, it should be the shareholders voting at their next meeting saying, I want a different, someone different to do, to take the lead on this. It's different. Being illegal is different than I don't like how you are operating the business. And I'm concerned that this is working toward being illegal types of decision makings, or at least ones that can lead to liability, as opposed to simply, I disagree with your view of what's important.
So I guess we're running low on time. I have one final question. Where would you like business law to develop from this point, whether it's the total elimination of social benefit corporation statutes, or whether it's a new understanding by state court judges, or whether there is some other intervention that should be done to turn back the clock on these developments?
First and foremost, I would like to see state court judges, particularly in Delaware, be more deferential to directors, absent some evidence that the directors have done something for personal gain or without regard to the impacts. And I think that they need to give a lot more latitude to directors to be able to say things in strong and clear ways, like, for example, Dick's Sporting Goods saying, we're going to do the right thing and I'm not worried about the bottom line. I think courts need to be able to look at that through the same lens they've looked at a lot of other things. One, we have the traditional concept of puffing in advertising, right? It doesn't have to be taken literally. And I think in this context, Dick's wasn't saying, I literally don't care what happens to the company. They were saying, we're not going to worry about it on the margins because we believe this is the right thing to do, and doing the right thing is good for business. Directors shouldn't have to go out, and CEOs shouldn't have to go out and say all the time, when I say that we're doing something right, I just want to be clear I'm being as cutthroat and as practical as I can be from a profit perspective. So I don't really mean what I say because profit comes first. Instead, I think they should be allowed to say, doing the right thing leads to a long-term benefit for our customers and our community. And by doing the right thing, we all benefit. And I think there's evidence to suggest that's true. Second, I would like to see the benefit corporations be removed and the benefit entity statutes. We have the option for nonprofit statutes. So a not-for-profit is a different entity where they really are not seeking the opportunity. And otherwise, I think if somebody wants to earn modest profits or major profits, is the decision, again, of the board of directors and how they run. And the traditional entity structures, particularly corporations, limited liability companies, limited partnerships, are fully capable of filling that area, and they should be allowed to do so.
All right. Well, thank you for coming up to the podcast to talk about your work, Professor Fershee.
I appreciate the time. Thank you very much.
I bring you tidings of great joy today. Within these stately walls, within these hallowed halls, will soon appear a man, but not an ordinary man, a man of great importance to us all. We'll make a visit. Tell us who is it? Oh, will you please tell us who is it who will visit? A man who is a leader among men today is here to give you the word again today. Oh man, you said it, and don't forget it, 'cause if you do, I'm sure that you will all regret it. You mean if we do, we're through? That's true. But if you sell your systems, lots and lots of systems, and keep on your toeses, do as he discloses, you'll be up to here, no need to fear. Encompass roses. Hallelujah, 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 hallelujah. Oh, tell us who's the man who will teach us right from wrong. We're getting out of breath from holding all these notes too long. Then the time has come to tell you who it is. We'll make a visit. Tell us who is it? Oh, will you please tell us who is it who will visit? The district manager. The district manager. The district manager. That's him again. That's him again. That's he. That's me. By George, I think they've got it. Men, I'd like to review our 1968 action program with you this morning. Now, if you'll just follow the bouncing ball, you'll get the message. The money that we make, rain. The sunshine that we bring, me. And you must do our best. If you don't, our heads will swing. So let's all put on some speed. Love. T-Doll will never do. The teamwork that you need. If you want to make more dough. Meeting adjourned.